Morning. As I outlined in our first hearing a couple of weeks ago, we're going to start taking a deeper dive into all of the issues surrounding sexual harassment in the Capitol, looking at not only how we strengthen our response when harassment and abuse occurs, but also working towards prevention and culture change. And I mentioned before that we want to hear from the Capitol community as we make these policies. And we want to hear people's feedback. We want to hear your recommendations about what's been working in the past, what hasn't been working, what kind of a workplace this is, because that's going to help direct the policy that we make. We are going to be embarking on a culture survey here in the Capitol. And we also have created a way for people to give us testimony and input without having to get up in front of cameras and in front of microphones. So I'm proud to let you know that we now have a digital suggestion box that people can use through the portal on the Assembly's website. And through that, you can share ideas with us without having to share your name if you don't want to. It's not to be used for reporting of harassment. I want to make that very clear. This is not the proper way to do that. This is more to give your suggestions and give your input to us in a way that's easy for people to do. And today we're going to be looking at how we define harassment. What is sexual harassment? I think there's a lot of anxiety across the country about what's acceptable and what's not acceptable. And the unique challenges that we have here in the Capitol facing us about how we define harassment. As we proceed through the agenda, I'm going to introduce our witnesses, but you can find out more about them on our on the witness list that's included in the members' material and on the subcommittee's website. The website also includes a background paper that can give you a bit of a primer on sexual harassment law, as well as the materials from our first hearing. With that, I'll turn to our Vice Chair, Senator Holly Mitchell, for her opening remarks.
None. I'm ready to get started, Madam
Great.
Chair.
I will ask, does anybody else have any brief opening remarks? Okay. So as in the first hearing, I'm going to ask everybody to hold their questions for each panel until the conclusion of that particular panel. And in the interest of full disclosure, two of our witnesses today have a connection, although it's a limited connection, to sexual harassment investigations here at the Capitol. And with that, I'll ask the first panel to come up as I introduce them. Wendy Musil represents a witness, let me just finish with the disclosures first. Wendy Musil represents a witness in an investigation in the Senate, and Beth West has a law partner in her firm who is currently a fact finder in an Assembly investigation, as reported in the news media last week. Ms. West, however, does not work on sexual harassment issues in the Capitol and is here with us today to share her perspective based on her experience in the private sector. So with that, we'll move to our first panel, which is legal perspectives on sexual harassment. Andrea Johnson is the Senior Counsel for State Policy at the National Women's Law Center, who comes to us via video from Washington, D.C., where NWLC has in recent months worked with Congress on sexual harassment issues. Wendy Musil co-chairs the Legislative Committee for the California Employment Lawyers Association, or CELA, and is a named partner at Seward & Musil in San Francisco, where she practices civil rights. Beth West is an employment mediator and a counselor for employees at the law firm of Weintraub Tobin here in Sacramento. Are the panelists all here? Yeah. If you can come up to the table, please, and join us. Do we have And do we have our, great, we have our panelist on Skype, and I think we're going to be starting with her. Can you hear us?
Yes, I can. Can you hear me?
We can hear you just fine. Thank you so much for joining us today.
Thank you.
You're on.
Okay. So my name is Andrea Johnson. I am Senior Counsel for State Policy at the National Women's Law Center in Washington, D.C. The Law Center has been working for over 45 years to advance and protect women's equality and opportunity. It's long work to remove barriers to equal treatment for women in the workplace. My role here at the Law Center as Senior Counsel for State Policy is with state advocates and state legislators across the country on a host of issues, from equal pay to pregnancy discrimination to fair work schedules. But the last few months, not surprisingly, much of our work has been focused on working with state and federal legislators to harness the energy of this Me Too moment to make real change and stop and prevent sexual harassment. So my colleague Maya Raghu, who unfortunately was able to be with us today, she has been involved with efforts to reform sexual harassment prevention and accountability process in Congress. I have been talking with legislators in several states about their efforts to reform state legislative processes. So that's why I'm here with you today. Unfortunately, I can tell you that the issues around sexual harassment and accountability that you're experiencing in the California legislature are not unique to that legislative body. The concerns you are grappling with are concerns that your counterparts in many other states are also grappling with. They were some common themes I thought would be helpful to share. One major theme is the fear of mechanisms for reporting harassment. A common issue in many legislative bodies is that staff of individuals do not know, understand, or trust existing mechanisms for receiving and resolving complaints. Another theme is failure of accountability. Harassers, especially those in the most powerful positions, held accountable at all or inconsistently. Harassment is often swept under the rug, allowing harassers to keep harassing. And the other theme was failure of current prevention practices are largely focused on training that are not regularly attended, if at all, and not effectively done. So these are things I've been hearing from across the country. We really, truly appreciate the thoughtful work that you are all doing to address these problems, and grateful for the opportunity to testify today to offer some recommendations and guiding principles for responding to inadequacies of our current system. I want to first start out by making clear what exactly it is we're talking about, what we're trying to fix here. Sexual harassment isn't about sex. It's an expression of power. This might be something you've heard before, but it's important to reiterate. Because of sexist, racist stereotypes and outdated workplace structures, women, and especially women of color, have less power in the workplace, increasing their vulnerability to exploitation.
Excuse me 1 minute, I'm going to just interrupt you. We're having a little bit of a connection problem. Can you maybe just slow down a little bit, because the connection's lagging a little. So if you can just slow down as you speak, that might help us understand you a little bit more clearly.
Sorry about that. Okay.
No, that's okay. It's not your fault. It's the internet. Okay, thanks.
Okay, trying to get a good connection. Not always easy. Okay. So as I was saying, sexual harassment is about power. Sexual harassment is used to enforce cultural norms about appropriate roles, behavior, and work for women and men, and to exert control over people with less power in the workplace, particularly women of color, immigrants, and LGBT. The power imbalance is especially acute here in this workplace context, where we have high-profile lawmakers, 80% of whom are men, and they interact with lobbyists seeking influence, and young men and women who are just starting out their career, serving as legislators and interns. And I want to really reiterate that sexual harassment isn't the only manifestation of power imbalance. Sexual harassment often occurs with and is further entrenched by other forms of sex-based discrimination, like pay discrimination. Also, harassment often contains offensive comments based on multiple identities, like national origin and sex, not just sex. And many women experience harassment because of a combination of their race and sex, or their disability and sex, for example. So in short, sexual harassment doesn't occur in a vacuum. And I bring this up because craft policies only focused on sexual harassment limits our ability to truly address gender and racial inequality in the workplace. We urge you to ensure that any reforms that you're thinking about moving forward with also apply to claims of workplace harassment more broadly understood, discrimination based on sex, which includes sexual orientation, gender identity, pregnancy, and race, and disability and other protected statuses under state law. That is something that we are speaking with all sorts of folks about, the importance of our response to this moment, not just focusing exclusively on sexual harassment, because harassment and discrimination are connected. And we want to make sure that we have greater protections of all forms. So I will focus on some recommendations we have around reporting, because from the reports of California and other states, it's clear that reforming the process of reporting about harassment needs to be a priority. Many victims and bystanders never report harassment because they fear losing their job or otherwise hurting their career. They also don't believe that their complaints will be taken seriously. They feel that the individual or entity responsible for investigating will just look the other way because the harasser powerful person or a superstar. I know that state legislatures are struggling with the fact that the entities responsible for receiving complaints of harassment are often members or legal counsel or committee or staff members whose duties are towards the members. They aren't necessarily an independent entity. This is an intimidating reporting structure, and one that many people don't trust to impartially handle their claims. So the legislator could promote reporting, make people feel safe by ensuring that there are multiple bodies or individuals, including, importantly, a truly independent authority to whom a person could report harassment and discrimination beyond only their supervisor, who might be the harasser. And on the point of an independent authority, I want to drive home that it's important that any independent authority tasked with conducting investigations and hearings must have the additional resources, authorities, and access to staff and members of the legislature needed to really do its job effectively. The legislature could also provide a mechanism whereby complainants are given meaningful legal and non-legal advice and support throughout, for example, through a counseling program. Moreover, it's important to ensure that non-disclosure agreements are not a prerequisite to making a complaint, nor a mandatory condition of settlement. We hear about this a lot in the broader workplace context. It holds true as well in the legislature. Finally, strong anti-retaliation whistleblower protections need to be a priority, and I know these are things we're looking at. And at the most basic level, that means ensuring that everyone is told through the policies, through trainings and counseling in the investigation process, what exactly retaliation is and what it looks like in many different forms, that it is illegal, that you can file a claim for retaliation, and that people who engage in retaliation will be held accountable. That really clarity in breaking down what retaliation is and making everybody aware of it is so important to encourage. On the issue of accountability, that's one of the last points I want to make. The lack of consistent accountability leads to reporting because people don't feel like anything will actually be done. This fear is especially strong in the legislature, where we are taking their offices hold a lot of power. But I want to make clear what we mean by accountability. Zero tolerance is a popular term, but it should not mean that the only consequence for any incident, inappropriate or illegal, is terminating the harasser. If you adopted that standard, one consequence would be that in practice, decision makers would ignore less severe forms of harassment because they would feel like they could terminate someone for making vulgar remarks, for example. They would be led to protect employees who harassed others but did not engage in sufficiently severe conduct that they felt merited termination. So we really urge you to develop guidelines and share those with the entire legislative workforce and the general public that identify harassing and conduct, the proportionate actions that may be assessed when violations are substantiated, and the process for doing that. And that is also an issue with reporting, that we are concerned people will be reluctant to report if they think the only consequence is termination for the harasser. And for legislatures, when we talk about accountability, we also mean accountability to the public. And that means transparency. It's the thing we've been focusing time on. We encourage the legislature to periodically collect and make publicly available a report detailing the number of harassment and discrimination claims asserted, regardless of whether they were resolved, and also the number of settlements and total award amounts by office. This information will allow taxpayers and constituents to have a clear understanding of the workplace culture and practices in each office, because not every claim of discrimination will result in a settlement or award. However, we want to drive home that any such report must protect the identity and confidentiality of the complainant, because revealing victims' identities can result in retaliation and adverse consequences for the complainants, including being blackballed from other jobs in the legislature. So with that in mind, we also encourage that any reporting that be done not occur more than once a year, and should avoid detailing the number of and of each type of discrimination claim filed per office per year. That makes it more difficult to relate that reporting directly back to an individual. We feel like that strikes the balance of victim privacy and transparency, which is very important. And it is crucial that if taxpayer funds are used to settle a claim, something we've been within Congress, that a legislator, if taxpayer funds are used to settle a claim, legislators should personally reimburse the beneficiary for funds expended on his or her behalf. And use of office funds by legislators to pay settlement amounts should be disallowed. So I have a number of other recommendations that are in my written testimony, and some going to prevention, though I think you might have another hearing on that issue specifically. Recommendations for making training more effective. One thing I will just say quickly is another prevention strategy, thinking about climate surveys and encouraging all employers, and I think this is especially important for legislature, to implement a regular anonymous climate survey of the legislative workforce that will help offices understand the true nature and scope of harassment and discrimination in the legislature, and identify any failures in the policies and procedures that are designed to prevent and address harassment and discrimination. So that is a good regular practice. We'll stop, and I hope you were able to hear me okay, given the connection issues.
Thank you. And if you can stand by, if that's okay with you, as we get through the other two panelists, and we may have some questions for you at the end.
Great.
Okay, thank you very much. Okay, we're going to move on to Wendy Mussel now.
Good morning. Thank you so much for the opportunity to speak with all of you today. I think this is a very important issue, and I'm glad that we have this opportunity to share our opinions on this topic. I am the chair president of the California Employment Lawyers Association, which is a statewide organization of nearly 1,300 attorneys who represent workers in discrimination, harassment, retaliation, wage and hour, and whistleblower, and other employment matters. Our members help protect and expand the legal rights of working men and women through litigation, education, and advocacy. I also have been representing public employees for over 20 years, and I'm an adjunct professor at the University of San Francisco School of Law, although my comments are solely my own and on behalf of the California Employment Lawyers Association, not on behalf of the University of San Francisco School of Law. I think one of the first things that this panel needs to understand is the unique aspects of this workplace. So each of the members has the ultimate hiring and firing authority. If someone is in your workplace who is experiencing sexual harassment or sex discrimination, or if they're a bystander, a witness to such actions, and they wish to complain about this or transfer to another department or transfer to another position that's exceedingly hard in this workplace. It's a unique factor of the Capitol. So for example, if you're a woman experiencing sexual harassment by a member, where do you go? You can't easily transfer. Additionally, if you're a staffer seeing inappropriate conduct in the workplace, comments that perhaps shouldn't be made, that sort of conduct, it's very difficult to come out and say this is conduct that should not be happening because of the lack of easy mobility in the Capitol. Because of the unique factors of this workplace, including the difficulty to discipline members who have engaged in sexual harassment, discrimination, and retaliation, that really has to be taken into account at this unique workplace. Because of that, I think you need even more stringent policies, procedures, and this really needs to be a zero-tolerance workplace. And the reason for that, in large part, is because otherwise people are not going to go forward. You're going to have years of entrenched behavior that doesn't come to the fore until you end up with multiple complaints of egregious conduct. So the first thing I think that this panel needs to think about is the unique features of this particular workplace, which is unlike other state employers where you might have the opportunity to transfer if you're experiencing sexual harassment or retaliation in the workplace, or a right of return to other state employment. That's why this has to be more stringent, and the investigation policies, procedures have to be followed to the letter. This also highlights the differential in power which already exists. So members, as elected officials, have a great deal of power that's entrenched in their position already. Given the unique factors of this workplace, that power differential is only increased. Part of what's required by an employer, whether you're the legislature or some other employer, is a past failure to investigate and remedy allegations of harassment is likely to contribute to additional harassment in the workplace and to encourage retaliation against those who complain. That was actually the Hawkins versus Hennepin Tech Center case, but I think it really says what we all know is if you allow harassment to flourish, it encourages additional harassment, and it also encourages retaliation for those individuals who do come forward to indicate that there's inappropriate or unlawful conduct in the workplace. So what do we do? I'd like to talk about a couple of very specific, tangible ways to address this. One is the statute of limitations. Because of the unique feature of this workplace, where it's very difficult to, frankly, complain and also to transfer, the statute of limitations of 1 year is especially egregious. The California Employment Lawyers Association, ERA, and CAOC have talked about, and there is before this body, legislation which would increase that statute of limitations to 3 years. I think that that helps address some of the issues of the difficulty of coming forward in the power differential. I think that's critical. There have been reports, and I'm going to forward on reports. I won't be sharing any attorney-client privilege or work product information I may have in my own individual capacity because I think that would be inappropriate. However, there have been reports in the media regarding no rehire clauses. Well, if you have a no rehire clause, if you've been subject to sexual harassment, discrimination in the workplace, where do you go? Not only do you not have an ability to transfer, but you're basically locked out of an entire career path. These no rehire clauses should be illegal as a matter of public policy, but particularly in this type of workplace where there's these egregious power differentials and a lack of opportunity. Confidentiality clauses. Confidentiality clauses in this workplace are particularly difficult and I think are against public policy. The reason for that is if you have a confidentiality clause, it covers the conduct that's happening in that member's office. It's hard enough to come forward. It's hard enough if you're a bystander to say, when you see something, say something, which is what we'd like to see. But when you have these confidentiality clauses, you could be barred as a matter of law from raising this. There are particular transparency problems with this body of elected officials where we're supposed to be doing business with the light of the sun. These confidentiality clauses are against public policy and against, what we hope all of our public officials are, which is acting in the interests of the public, not in their own private interests. Arbitration clauses. This has been in the media, and I know it's been discussed before this body. This week, actually, the National Organization of Attorney Generals, I believe it was 56 of them, came out and said, particularly as it relates to sexual harassment, arbitration clauses are against public policy. They're against transparency, and they allow repeat players or repeat harassers to exist and to continue with this unlawful conduct. I have provided that document for your review, which again was signed by 56 attorney generals across this nation. The policies themselves that govern this body have to be looked at. One of the issues, which I think is a wonderful step in the right direction, but I think falls short, is the ability of victims to go straight to weave. Now, it's wonderful that there is a place that individuals can go and to discuss their experiences and perhaps get help. The problem lies is that it's not considered a protected activity. So if this body says to a person who's a victim of harassment or retaliation, go to weave, but don't tell them this is not considered a protected activity, and thus you are not covered by the whistleblower laws. If you do that, I think that's a major problem. Either we need to say, as a matter of public policy, if you're telling people to go to Weave, that is considered a protected activity, and you will be covered by our whistleblower laws, and or you need to tell those individuals who come forward with harassment, discrimination, and retaliation claims, if you choose to go to Weave, that is not a protected activity, and you will not be covered by the law. The individual who is a victim or survivor of harassment, discrimination, and retaliation should at least know where they stand. If they're told under the policies to report someplace and where they're reporting is not considered a protected activity under the law, that's a major problem. Regarding investigation, I think it's wonderful that there are investigations that are starting. I think it's important for transparency. However, when we look at investigations, we need to determine certain guidelines and transparency regarding those investigations. Some of the questions that I think need to be answered as it relates to those investigations are, what are the roles of the persons in the investigation? What are their qualifications and experience? Do they have any conflict of interest or bias, i.e., do they represent the Assembly, the state, or any of the accused? The likelihood is none of those things are true, but the people participating in the investigations need to know that up front, rather than as they wade into the investigation asking these questions on an ad hoc basis. Will individuals who are performing these investigations be precluded at a future date from representing the Senate, the Assembly, or any of the accused? These go to conflicts of interest issues or perception of conflict of interest. Even if there isn't a current conflict of interest, if the people who are subjected to harassment, discrimination, and retaliation in the workplace, or are bystanders who would like to come forward regarding inappropriate conduct, if they feel that there are conflicts, or if they feel that the perception is that the deck is stacked, then they're not going to come forward. So these issues have to be addressed at the front end, and they have to be affirmatively communicated. Are there any policies in place regarding any conflicts of interest which may manifest in the future? Those need to be contemplated up front. Additionally, is there any waiver of attorney-client privilege and work product with the investigative report? If you cover investigative reports, if you have attorneys do those and then decide that they're covered by attorney-client privilege and work product, that's very problematic, I think, for the Assembly and for the Senate, because it means that there's a lack of transparency. You're also asking employees to come forward where they have significant fear of retaliation, but never providing them with any data of what happens. Additional questions which need to be answered is who gets the reports and what happens to them? Where does that data go? Where is it distributed? If you're a witness afraid about retaliation in the workplace and you don't know where your data is going, who's going to be reading it, how it's going to be distributed, you're unlikely to come forward and share all of the information that you have in an open and honest way. Additionally, what's the scope and the mandate of the investigation? If there are other identified problems in the workplace, let's say one person comes forward with a report of inappropriate conduct in the workplace. The investigator goes in, talks to other witnesses, and finds out, lo and behold, this is a pattern or practice in the workplace. There have been other people who have been touched inappropriately, other comments that have been inappropriate in the workplace. Is the investigator allowed to look at those issues? I would posit that yes, if you are opening up that investigation, you should allow the scope of the investigation to encompass those issues, because it is your legal duty to address all issues of harassment in the workplace and to utilize all remedial measures, which under the law is an effective investigation. If an investigator is presented with unlawful conduct in the workplace, this body should allow the investigation to look at that, as opposed to pretending that there's blinders and it never happened. That deep sixes the information and encourages unlawful conduct to flourish. What about access to prior and subsequent complaints? When there's one complaint, it could be even a minor complaint, let's say, if one can be called a minor complaint. But if there's been 3 or 4 complaints against the same member or the same staffer, it begins to look like a pattern and practice problem. And so The issue of whether there's prior complaints or subsequent complaints is extremely relevant in order to get a picture of what's actually happening here. The converse is true. If there weren't any other prior complaints and the member has deemed to be acting appropriately in every other way, and if the complaint is of what could be considered a minor issue, that also should be taken into account. But we can't evaluate that unless you know, are there prior complaints, are there subsequent complaints, and what were the nature of those complaints? That also goes to record keeping. What are you doing with record keeping? Are you keeping these prior complaints? How are you accessing that data? Who is that data available for? I would posit at the very least that should be available to investigators. If I'm an investigator going in to find out if a member acted appropriately or inappropriately in the workplace, one of the first questions I want to know is, were there any prior complaints? What were the nature of those complaints? When did they occur? How did they resolve? Did anything happen to that member? Were they disciplined in any way, or was it found that there actually no inappropriate conduct happened? These are central questions, and I think this body needs to decide what record keeping. There are certain confines of law that you must abide by, but separate and apart from that, in terms of transparency and also for the best practices, those prior complaints should be kept in a manner that is easily accessible. It's very easy to put that in a database. I've seen that at other state agencies that I've sued. What's the standard of proof? When any fact finder is looking at a set of facts, you need to know, what's your standard of proof? Is this preponderance of the evidence? Is this clear and convincing evidence? Is this beyond a reasonable doubt? That matters, and that has not been articulated. So we need to determine what our standard of proof is. Often investigations will use the preponderance of the evidence, which is more likely than not, but whatever the standard of proof you're going to use, it needs to be understood, articulated, and set forth before you start the investigation, because otherwise, how does the investigator know what he or she is supposed to do? And how are we supposed to evaluate that evidence? If it's beyond a reasonable doubt, well, that's a very different standard, and I would posit that would be an inappropriate standard, particularly in this context, and where you're looking for zero tolerance. I would say that would be an anathema to that, but as a body, you need to make that determination. Additionally, we need to look at, are there potential concerns for bias regarding the investigators? If you're hiring people who may be outstanding attorneys, they may be very fair, but if they always defend employers, what message is that sending out to those individuals who might be complainants? They may be less likely to give, information if they feel that this is a firm who may be outstanding, who only represents employers. It gives a perception of bias, and the perception of bias is just as important to a complainant as actual bias. Regarding the policies, while I think the policies that are in place are a good start, there are some conflicts within the policies themselves as it relates to what's considered a complaint or report. It appears that there's some conflict. I think any articulation, whether you call it a complaint or report, should be looked into regarding harassment, discrimination, or retaliation. There shouldn't be a differential in the policies regarding when you investigate and when you don't. If you receive information that there's discrimination, harassment, or retaliation in the workplace, that should be subject to an investigation. It should not be up to discretion. It could be a short investigation, nothing actually happened. It could be you find that you're just scratching the surface and there's a lot of other victims. But having a differential in your own policies regarding the term report or complaint leaves some things on the table. Are there women or men coming forward indicating that there's inappropriate and sexual conduct in the workplace that never gets looked at because it's considered a report versus a complaint? That's a major issue. Who determines and how they determine what should happen and whether something should be investigated? I think that's a hole in your policies and procedures that needs to be looked at and clearly articulated. Additionally, permitting internal investigations and resolution by a supervisor. That's rife with conflict. If I'm a woman complaining about sexual harassment about my supervisor, am I supposed to go tell my supervisor and my supervisor then gets to determine what happens? That's obviously situation that we can't allow to stand, and that's not a zero tolerance policy, and is certainly nothing that would pass the smell test under law. And I think that loops us back to record keeping. I think in order to have, which will wrap up my time, these are issues that I think the policies and procedures need to be clearly articulated. They need to be articulated up front. The standards regarding the investigations need to be articulated up front. And there needs to be an open platform so that when individuals do see something, they feel comfortable saying something. And I'd be happy to entertain any questions.
We're going to be asking questions at the end of this panel, and then the last panelist on this panel is Ms. West.
Thank you, Honorable Chairwoman Friedman, Vice Chairwoman Mitchell, and distinguished committee members for allowing me to speak to you today. By way of background, I am an employment lawyer, and I've spent the last 18 years representing employers in all aspects of their employment relationship with their employees. Part of my practice focuses on educating and training employers on combating bias and preventing harassment and discrimination in the workplace. I am also an employment mediator and assist parties in resolving disputes both pre and post litigation. And I am a contributing editor to the harassment chapter in the Rudder Group's Employment Litigation Treatise, which is utilized by employment lawyers in the state of California. Well, it's probably evident to the committee, I'm also a woman. And I am also an employee. So the issue of sexual harassment, the problem of sexual harassment in the workplace, I have not been immune to in my career. And it is my goal when I work with my clients to help them prevent harassment happening in their workplace. I want to start by saying that I commend and support all the many women and men who have come forward in the last few months and told their stories in different industries, including in this legislature. And I'm encouraged that the spotlight that's been placed on the issue of sexual harassment will continue to result in bodies like this subcommittee taking meaningful steps to try and protect employees from harassment. I was asked to present today on challenges that employers continue to face in trying their best to prevent harassment in the workplace. In my time allotted, I'm going to talk about a couple of challenges they face with respect to having an effective anti-harassment program in place, and then I'm going to discuss a few legal challenges employers continue to face when harassment complaints are in fact filed. One of the most difficult challenges employers face is really getting true buy-in from leadership. The EEOC task force, which issued its report in June of 2016 and is summarized in the background paper that was provided to you, made very clear that leadership in every organization, including this legislature, must be committed to a workplace free of harassment. Absent that commitment, it's very likely, almost probable, almost guaranteed, that sexual harassment is going to continue. Also, an organization has to have accountability systems in place to ensure that those who engage in harassment are responsible in a meaningful and appropriate manner. Merely having policies in place and conducting training will not be enough if these two core components are not embraced by this legislature: leadership buy-in and accountability. Lip service isn't enough. The zero tolerance policies that the Assembly has in place and that the Senate has in place, they need to be complied with by everybody who works in those two bodies. Now, I agree with Ms. Johnson's comment on a concern about zero tolerance. And I also agree with my panelist, Wendy, with respect to some improvements that can be made in some of the policies. And I'd like to finish my presentation and then maybe address some of those if we have time. But lip service is not enough. Like other workplaces, this legislature will also continue to struggle with power dynamics and the issue of very influential and high-valued employees. The legislature has very high-powered, influential people, some of whom may believe that the rules don't apply to them, or some who may believe, genuinely or not, that their conduct is somehow different than the conduct that's being described in a policy or being discussed in a training session. But there can be no exceptions, none. These individuals, regardless of their stature, must be held to the same standards and must be held accountable for their conduct. In addition to power dynamics, sexual harassment often involves biases, both conscious and unconscious, and stereotypes about the roles of men and women in our society and in our workplace. And I submit to you that part of a rigorous, effective training program to prevent harassment in the workplace must address biases. Not just recognizing that they exist, but actually exploring tools to combat them. There are many studies out there that show we all have unconscious biases, every single one of us. There's a Princeton study that said the second you saw my face, you've made a decision of who I am. And the second I saw all your faces, I did the same thing. We operate on unconscious biases and we're not aware of it. Doesn't make us bad, but it does mandate that we use self-reflection to determine if some of those biases or negative prejudices that are motivating our actions and conduct in relation to other people. And there are lots of resources to help this body do that. The Kirwan Institute, the Cook-Ross, a woman-owned consulting firm that specializes in this. I believe in your previous hearing, you had a speaker who addressed this issue. There are lots of resources. Another challenge faced by employers is that employers have to balance employee rights when taking action in response to sexual harassment. Under the law, while employer has a duty to take action that is reasonably calculated to end sexual harassment, it must also consider rights of the accused until such time as the determination is made that sexual harassment occurred. Employers may feel as if they're caught in a double bind when determining what steps to take, what effective disciplinary measures to implement to stop harassment. There is case law that says the disciplinary or remedial action that is taken cannot be or should not be disproportionate with the harassing conduct. There's also issues employers face with potential legal suits from the accused, not just the harasser, not just the victim of harassment. Potentially wrongful termination cases. There are defamation cases that are being defended in court. And this happens if an employer fails to have fair, objective investigations that give all parties an opportunity to participate, or if an employer jumps too quickly to make disciplinary decisions based on faulty findings. Therefore, it's really important in any anti-harassment program that an investigation be prompt, fair, neutral, and objective. And my colleague Wendy identified, it is very important up front to determine if there's conflicts of interest or biases. You have to have the right investigator. All parties in that investigation have to be given the opportunity to participate and heard before any finding is made and action is taken. Finally, employers continue to struggle with their strict liability for supervisor harassment. If sexual harassment is committed by a supervisor, an employer is strictly liable, even if upper management and owners of an entity, in this case, even if the members of the Assembly and Senate had no idea that a supervising employee had the propensity to engage in that conduct. While federal law might provide limited defenses under Title VII, under what's known as the Ellis-Farragut defense, to employer liability when a supervisor is found to have harassed, there is no defense to liability under California law. Now, there may be a potential to reduce damages under what is known as the avoidable consequences doctrine, but there is no defense to liability for the employer. Consequently, employers, like this legislature, are faced with the harsh reality that even if they have a robust anti-harassment program in place, with these components, a comprehensive policy tailored to the workplace, effective training, secure reporting mechanisms, fair and impartial investigations, appropriate and effective discipline and remedial measures and protection against harassment, they still face liability if a supervisor violates that anti-harassment program and engages in harassment. Now, I know under the government code, the legislature may have some recourse and recoup, defense costs or something to a member or a senator who, if he or she happens to be the harasser in that situation. But the fact remains, liability is attached under strict liability. What's the answer for the legislature? I'm not sure there is a perfect answer. Employers are not seeking to avoid liability when it's been determined that they've done something wrong. Instead, what they're wishing to seek is to have a meaningful defense when it's determined that they did things right, but yet a rogue supervisor still engaged in harassment. Maybe one of the answers under California law is an amendment to the Fair Employment Housing Act to come up with a defense in line with and comparable to the Ehlers-Faragher defense. I leave that idea in your capable hands. I would like to just address a few things in the policy, some of which the other panel members have discussed. The zero tolerance policy that is expressed in both the Senate's policy against harassment and the Assembly's policy against harassment could raise some concerns because, as Ms. Johnson said, it does seem to convey that any form of harassment results ultimately in termination of employment. And as I indicated, there is case law that makes clear that disciplinary action should be appropriate based on the findings of an investigation and the extent and egregiousness of the harassment. Therefore, it may not be appropriate. It may be disproportionate and to have an absolute zero tolerance policy. The Assembly policy also seems to indicate that investigations will be done if a complaint of inappropriate or harassing conduct is made within 1 year of the conduct. Now, I understand, or I believe I understand the rationale for that time limit. It's in line with the current 1 year period in which employees can report to the DFEH. However, I think it's important to be mindful of two things. An employer should never deny investigating inappropriate conduct in the workplace, no matter when it's brought forward, because we always have a continuing duty to make sure, and as my panelist Wendy pointed out, there may be other conduct that's going on with respect to the coworkers of that person who comes forward, and it's our duty as employers to get to the bottom of it. But from a legal standpoint, there's also a doctrine called the continuing violation doctrine. And so you may have an employee who comes and reports something to you that happened over a year, something egregious potentially, that happened over a year ago, and you think under your policy they didn't report it timely. But if other micro inequities and harassing inappropriate conduct has happened within that 1 year period, that egregious conduct that was happening over a year ago can be brought in to the current evaluation of whether we have a hostile work environment or some other harassment in the workplace, some actionable harassment. So we should never put a time limit. Now, we should encourage prompt reporting so that we can fulfill our duties to take prompt action and investigate, but we should never put a time limit and say that we will only investigate if you report it within a year. The other issue that's raised, and my panelist Wendy addressed it, with respect to the reporting and resolution of some complaints by a supervisor. She brought forth a very good point that if the supervisor is the harasser, then it's surely not reasonable that that's the reporting point that an employee has to go to for redress. But even more so, a supervisor should never be the one to investigate or resolve any claim of harassment, even between cohorts and peers, if that supervisor has not been trained on how to do that. That can only expose the employer to more liability if they get it wrong. Thank you very much for the opportunity to speak to you.
Thank you. It's all really great and very comprehensive information. I'm going to open the panel up now to questions. And do we have our third panelist available? So I'll start with a couple of questions. So one of the things that you mentioned, that you've talked about, thank you, that I've been trying to grapple with in my own mind has to do with the idea of zero tolerance, as you talked about, as being in some ways problematic, but also wanting to make sure we have accountability and we don't allow workplace abuses to continue. I don't know if you had a chance to see our last panel, but we had people from the human resources world come in, and we also had a professor who studies culture change and sexual harassment. And one of the things that they all said pretty consistently was that you do need to have accountability, but at the same time, you want to get to a workplace where people feel good coming to work, where you have mutual respect, and that the more you focus on accountability and punishment, the more toxic of a workplace you can create, because people become afraid. They're afraid of their interactions with each other. And I feel like we're getting to a place here in the Capitol, quite honestly, where people are afraid. They're afraid of whether their behavior crosses a line. So my question is both about where is that line, and how do we start to understand what's considered acceptable and what's not, because that seems to be a moving target right now. That's number one. And number two, how do we balance having a place where people understand that there are penalties for acting inappropriately, but also where they're not afraid about all of their behaviors?
Well, I think zero tolerance policies don't mean that the remedy is always expulsion. And I think, frankly, what to do in this particular workplace, because you're elected officials, that becomes even more difficult, right? This isn't a normal workplace where you could be fired and you're out the door. So I think in any workplace, however, zero tolerance does not mean that it's a predetermined remedy, i.e. there could be training, there could be some lower form of discipline prior to expulsion. So I think those are two separate constructs. One is, this is not the kind of workplace we want to have. We're going to have a zero tolerance for harassing, discriminatory conduct and retaliatory conduct in the workplace, which is at the far spectrum of employment actions. The vast majority of day-to-day interactions are not harassing, discriminatory, or retaliatory in the workplace. I think the idea that there's some sort of overcorrection is actually not true at all. What the conduct that's come out here at the Capitol, I think we could all agree that the allegations, of course these have not been determined yet, so I'll keep with allegations, are egregious conduct that anyone could determine that you don't do those things in the workplace. This is not, the things that are coming out are not, I have a taking you to lunch and we're having a nice conversation about my children or something like that. The conduct that's coming out is vastly different than that and is very sexual in nature and or explicitly retaliatory. So I think that looking at the conduct that's alleged, this isn't run-of-the-mill conduct in the workplace. So I would be wary of any sort of internalization of an overcorrection or that being overly PC in the workplace. I think that's actually not happening at all. I think what you have is at the opposite spectrum, that you have historically you have a workplace that's afraid to come forward. And so what you have is a bottleneck. And so women and men are coming forward with egregious conduct that has just frankly not been brought to the fore because there wasn't a safe space for it. There wasn't clear policies and procedures. And there was certainly concerns regarding backlash. I mean, there's a reason why over 150 women signed a letter saying they've been subjected to sexual harassment or inappropriate conduct of an egregious nature. That didn't happen by accident, and those aren't run-of-the-mill employment discussions. So I think we need to look at the zero tolerance does not mean you're prejudging what you're going to do about it. If you need to take that on a case-by-case basis, and I agree under the law, it does say that you look at what the conduct is as to what the remedy ought to be. That's consistent with the law, and I don't think that's inconsistent with the policies or where the policies are going with this body.
Your question, I think, is fair, and I don't think it's unique to this body, actually. I was attending a legal conference in San Francisco last week, the Women Lawyers 2018 conference, and this exact issue came up, where there's a sense of walking on eggshells, at least that's what's being described, and that people are trying to overcompensate in a irrational way. For example, in a law firm where a male partner has a number of associates on his team, and if the case requires that there be travel out of town, he is not going to invite the female associate to accompany him because he's just not even going to put himself in that situation for fear of some false report. Unfortunately, I don't think that that's a fair reaction. I think all of us know, we're all adults, as to what our conduct needs to be. The law requires that we self-censor before we say and do things, right? Our intent doesn't matter, the impact does. And I think this overreaction, this fear that you described and what other people are describing will find its way back to some sense of normalcy at some point. But because of what we're hearing in the news, in the press these days, that is a reaction. There's no legal answer to that. The standards have been in place. The standards are going to remain the same, and everybody has to be held to them.
And if I may add, so this is something we're thinking about a lot. As you recognize, the media attention has been focused a lot on the most egregious forms of sexual harassment, notably sexual assault and criminal justice type responses to that, which I think has skewed the conversation. Sexual harassment involves a range of behaviors, and it also involves a range of responses to those behaviors. And I think we all, as advocates here on the panel and as legislative bodies, can play a role in trying to nuance that discussion a bit more and educate the public about what harassment looks like in all of its many forms, and the type of responses that might be appropriate in each circumstance. And I think effective harassment trainings will go through that and lay that out. And actually, we had a sexual harassment training here yesterday, appropriately. And, a lot of the focus was on the sort of smaller forms of microaggressions and harassment and just things that you do that make it really hard for people to do their job. And I think that's where we need to be focusing the conversation, is all these things that have been happening in the workplace that make it so hard for women to go to work and succeed. And that's what we're trying to stop. And there are a whole range of levels of responses to that. So I think we have a responsibility to nuance that discussion around sexual harassment, and that will help, as the other panelists say, kind of bring this conversation back to a comfortable place.
Thank you. How do you balance the public benefit and expectation of transparency against confidentiality, particularly when it comes to talking about releasing data for particular offices, when some of our offices are 2-3 people large, and it would be impossible to protect the identity of a victim or of a witness? Is there some legal standard of how that's done, or how you judge that? And in addition, how should we also consider releasing information about member transgressions when there is that continuum of offense? So is the expectation that, with a member, let's say, that you would release anything that violates our policy to the press or to the public, or only those egregious cases? I mean, how would you advise us as we craft this policy?
So I think this is a unique body, and you're all elected officials. And the person who you respond to is the public. This is not in a private corporation. There are different interests here. My answer might be slightly different for a private corporation than it would be for this particular body, where what you're doing is for the people. And the actions that you take are supposed to be under the sunshine laws in the light of day. I also think where you do have such a grave power differential, that needs to be taken into account. And one of the best things that we've seen to address that power differential is sunshine. Look at the Weinstein matter. Because of the great power differential in that particular industry and for that particular individual, those abuses were allowed to go on for far longer than they ever should have. the same sort of considerations must be considered here, particularly as it relates to if you find that there's violations of policy or procedure. Of course, I doubt you're going to be addressing whether there's violations of law with your investigations, although that's something you ought to consider one way or the other, whether you're doing that. But assuming that what the construct is there violations of policies or procedures, I think describing what those are, I think putting that information out, the public is not stupid. They can evaluate these things. If it was a conversation, one conversation, one time, which was not laden with profanity and sexual innuendo or quid pro quo, very different than a sexual assault. I think the public is able to evaluate that and has the right to evaluate that, because they have to ultimately decide, do we want to have that member come back? Are we going to vote them back in? And I think we're seeing that on a national scale as well as on the state scale, is the people do have a right to know, which is different than a private corporation, where I would argue there should be more transparency and more record keeping, and that is a matter of public policy that ought to occur. However, there is about a greater balancing of the right to privacy in personnel records, particularly when it comes to a private employer as opposed to this body. I do think concerns about individuals coming forward, there is a great deal of fear about retaliation, and it's real. And the idea of blacklisting is quite real, where individuals feel that if they come forward, they might not get a job in this city or in this building. And I think that also has to be taken into account with the culture change and the policy, procedure, and investigatory changes. Because if I'm considering coming forward, I need to know what's going to happen to me and where my data goes. So in order to allow that individual to make that decision about what the consequences would be for that individual to come forward, you want an atmosphere where they feel comfortable. Part of feeling comfortable is if they come forward that actually something happens, that they're not making a complaint and then there's no action, there's no investigation, and then they hear 2 years later the same thing happened to another woman or another man. So part of the consideration is not only concern of the immediate discomfort of that person who's a witness, but also if they're coming forward that it's going to be effective. Nobody, just like if you're bringing up safety issues, you want to make sure that's fixed so that other people don't end up in the same problem. If you have someone who sexually assaults, worst case scenario, and you make a complaint, your expectation is, I make this complaint, those sexual assaults stop. So that's part of what this body needs to consider as it balances issues of transparency versus privacy.
I'm not sure I have much more to add, except I would, encourage the protection of the integrity of investigations as they are going on. I think it's very important that an investigative process have integrity and that we remember that they are allegations until there's a determination made that based on the appropriate standard of proof that it did or did not occur. And if there is going to be disclosure and publication to the public, as this body is required to do, I think it's important to make very clear whether or not something was substantiated or unsubstantiated after a fair investigation.
If you have a comment about being able to protect witnesses and victims' confidentiality versus the desire for transparency, do you have any experience with that, or is that something that, how do you take that into account?
I think this is a key issue. Some individuals, I currently represent individuals, some who wish to come forward and are very happy to talk to the press or to talk to whomever would like to listen about what happened. And I have others who really would rather not. And so because they're afraid of retaliation, because they'd like to not think about it, because it's their choice. And so I think that is a major issue. I don't think at the point an individual makes a complaint and provides documentation that immediately, before an investigation, needs to be publicized. I think you have to have a process for that. Ultimately, however, I think there has to be the findings. And whether this body considers some redactions about particular witness names or victims' names, that's something you're going to have to grapple with. Because I do believe that there is reasonable positions on both sides. But I think part of why people are afraid to have their name come forward is because of the adverse consequences to them. And so we have to examine that at base. If those adverse consequences to them are handled, or they feel that they're being handled, they're more likely to not be as concerned if their name is included in some sort of public document. But if they feel the report goes nowhere and the conduct continues, then understandably, they're going to have a greater concern.
Sally?
Thank you, Madam Chair. Thank you for your testimony today. So I have a question first. So in the cases that you work on, are they all based off of California law as it stands today?
So in my firm, we represent individuals who are federal workers, so under federal law, you have to be, state workers, both in state agencies as well as counties, police departments, and private employers. So the body of my, whom I represent covers all of it. So we do look at comparatively federal law versus state law, and we look at where would we like to bring cases, what's the venue, and why.
I think you misunderstood my question, so maybe I didn't articulate it well enough. So I'll preface it with, I just asked my colleague here, or not my colleague, actually one of our staff, if he signed he's an at-will employee for the state assembly when he took his job. I'm an employer myself, privately outside of the Capitol here, and there's all kinds of laws. In fact, we have to post them on the walls for labor laws that we have that are state laws. So the cases that you try, every person that you represent has those laws in the back, so that when we talk about sun shining out the laws. So at the Capitol, you know, the worst job in the Capitol is the HR person if you have all these at-will employees and they have no laws that back them up. I'm assuming that so.
Well, the Fair Employment and Housing Act, as well as Title VII of the Civil Rights Act, applies to all employers, including the Capitol, regardless of whether you're an at-will employee or whether you're in unionized workplace. Those are two separate issues. So you as a private employer are obviously covered by the Fair Employment and Housing Act as well as Title VII, as is this body.
So when we work, so this is a question. So when we're at the end of session and we work a 15-hour day, we should be paying our employees time and a half?
Well, that's a really interesting question.
I can answer.
I would say, before she answers specifically your question, is I would ask this body, why do you want to pass laws that you won't apply to yourselves? What makes the legislature special that they should omit coverage? Why should they require employers in California to follow laws that they're unwilling to follow themselves? So just as a public policy question, you know, in whistleblower protections, as well as other areas, one has to ask oneself, if you're passing the laws, why wouldn't you apply it to yourself? But she can answer the specific wage and hour question.
I was being a little facetious in the off-topic that you brought forth, but, you know, as a true lawyer response, it depends whether you have to pay your employee overtime in that scenario, depending on their exempt status and so forth.
So the question earlier I heard from the person that we're Skyping in is that this is about power, not about sex, is what I heard. And so if you put the position where you have that more power, in the case of my company at home, my employees have rights, and they know those rights, and we have to display those rights to them. So they have some power when things are not right. Okay, if I do something to them that's not right, like not pay them right, not do there's a whole host of laws, they have power to retaliate back so that they're not in a situation where I have too much power over them. They have rights. do our employees in this Capitol have those same rights? I don't think so, because we don't abide by some of the same rules that I have to in my private world. And that sets up a power structure where she talked about the case where because you're at will, you can be fired without cause, basically, even if there's no ability to come back. So I guess that's what I'm trying to do is figure out how we get ourselves in a position where, because hopefully after all this comes out, we're going to put some policy in place that will help the person or the people who are in that HR department have to figure out where we go forward to represent both the employer and the employee.
Luckily, in this area, the laws are the same, meaning under the Fair Employment and Housing Act, this body is covered, same as they are at my business or your business. And so that is not an issue that you have to tackle because the legislator is expressly covered by the Fair Employment and Housing Act, which covers harassment, discrimination, and retaliation in the workplace. The at-will doctrine does not obviate that because you can hire or fire somebody for good reason or no reason at all, as so long as it's not a discriminatory reason, it's not because of a protected status, or not because of a violation of state or federal law or policy or regulation. You can say, I say that a lot to people who call me. So as it relates to this issue of sexual harassment, discrimination, and retaliation, this body is covered, and luckily you don't need to address that at this juncture. I also would hesitate to argue that 1102.5, which is the Whistleblower Protection Act, is that this body is not covered. Now, there's no appellate case which squarely addresses that, but I think this body should act as though and wait for the appellate courts to make their way. There's going to be, I'm sure, a case at some point which squarely addresses that as a matter of law. And that the current whistleblower legislation that was just passed should be augmenting 1102.5 as opposed to in place of 1102.5. So I would argue that this body ought to consider itself covered under the Whistleblower Protection Act. Perhaps you may even wish to, in legislative findings, clarify, yes, in fact, we are, and that's indicative of prior law, and it's simply clarifying, yes. There is no appellate case law on that. So I think as it specifically relates to what we're dealing with here, which also is about retaliation and whistleblowing, that there's the new legislation, and I would argue 1102.5 already covers it. But again, we'll have to wait for the courts to give the final word on that.
I think to truly be helpful in this process, as we gather information and data about how to create a system that is fair and just, it would be naive of us to continue to operate under the assumption that the power dynamic is, almost a one-way street between elected officials and staff. It is much more complex than that. You referenced the 150 women who signed on to letters. Many of them were women from Third House who talked about the dynamic of Third House power brokers and their influence on this building. We have legislative colleagues who feel that some of the attention that's been brought to them is as a result of external brokers who have vested interest in the outcome of policies that happen in this building, influencing the process. And so to simply assume that it's legislators and staff is naive, and we can't afford to focus on just that relationship. It's broader, which makes this process and the policies we have to come up with much more complex and layered. And the notion of bias comes into play as well. Given that complexity, what concerns me is the terminology we continue to use that can be interpreted by different people so many different ways. And so perception of bias, zero tolerance, accountability systems, transparency, due process, figuring out how we develop a culture where we can clearly define what is harassment and what the policies and procedures will be to address it, I think is has to be at the top of our agenda, and so everyone has clarity about the process and how they can be protected. My colleague asked one question in terms of balance, but I've got another based on just the news, and it continues to evolve and unfold every day. And that's when complainants come forward and choose, it is a choice, to remain anonymous. And how we then begin to, in this desire to have a transparent process, how we guarantee due process for all the parties involved when people come forward and wish to remain anonymous. I'm not convinced that we can have a system where people feel comfortable around perceptions of bias, et cetera, if that is to continue. And so I'm really curious about your response to that.
Well, I think you brought up two issues. One is if there's political payback, which I think is part of what you're
Right.
referring to.
Right.
That should come out in the investigatory process. That's certainly a concern about bias and credibility. And bias and credibility should be part of any competent investigatory process. So those are things that in any investigation, whether it's this body or in a private corporation, whether there's ulterior motives, and credibility concerns on all sides. Those are things that very fairly should be considered in any competent investigation. So regarding the issue of anonymous reporting, I think there's a reason there's anonymous reporting. And part of it is the fear of retaliation. But of course, once you receive that anonymous report, you have to do something with it. And there has to start to be an investigation. And it depends on what entry point. It could be, let's just say hypothetically, you receive a letter that discloses certain conduct by members. Then an investigation has to start, and usually there's enough information to start that investigation to make determinations one way or the other. And surely credibility and bias concerns should be a part of that investigation. If it's one member and it says these things have been happening in the staff, well, you know who the staff is. It doesn't take rocket science to talk to who's in the staff or to go back, who was the staff last year or the year before, who are the people that they had, where did they go for various events and what happened at those events. I think it would be, I would not want us to assume simply because you're allowing an avenue of more information to come into this body through anonymous reporting that there's any indication that that means that this body could not adequately investigate those issues.
That's not my assumption. That's not my assumption at all.
If I can touch upon
Sure.
that, I actually was retained as a neutral investigator in response to an anonymous letter in a rather large statewide agency a few years back. And it does pose some challenges that other investigations don't have when you know who the complainant is. But as Wendy indicates, it doesn't forgive the employer's obligation to investigate. And remember, the standard under the law is not that we absolutely get everything right when we investigate. We have the Cotran case. It's been on the books for many years from the California Supreme Court case that says employers have to act reasonably. We have to take reasonable steps to try to determine what in fact happened, and if something inappropriate, unlawful happened, we have to take appropriate remedial actions to stop it and prevent it from happening again. And so anonymous complaints have to be investigated like any other complaint. It's just you're going to go through maybe some different measures to do it. And you're going to be reasonable once you make a finding, and you'll take the appropriate remedial steps based on those findings.
I appreciate that. Last question, Madam Chair. With regard to retaliation, it of course is our collective goal. I'm sorry, were you going to say something?
Sorry, thank you. Yeah, I just wanted to add that recognizing the difficulty of reporting and the power imbalances that make it especially hard within a legislature, we are excited to see more legislatures and Congress considering climate surveys, which is a way to get sort of more generalized information about what's going on, prevalence of harassment, the efficacy of the policies and procedures, and just recognizing that there will still be people who won't come forward, having some sort of way to collect that information through a climate survey is important, and I think addresses some of the issues here.
I agree, and happy that the legislature is conducting one as we speak, or is at least beginning the process. I think with regard to retaliation, of course, it's our collective goal to create a culture and a workplace where retaliation isn't at the top of one's list in terms of fear about stepping up and protecting their own individual rights. I am curious, based on your collective experiences, if you can point to a circumstance or a workplace where a system was put in place where retaliation was never a question. And I say that because my concern is we have these extreme expectations. And I'm not convinced, and I am open to be convinced otherwise, that a system exists where there is absolutely no opportunity for retaliation. And I don't want to create an expectation that we, even though there's a higher standard because we are elected officials and we have a responsibility to the public, both in terms of our conduct, our behavior, and public resources used. But the piece around retaliation and an expectation that I'm protected, period, I don't know that that's reasonable or realistic.
I think that's a fair concern. Unfortunately, statistics show that when we're talking about harassment, discrimination, retaliation, it is retaliation that occurs more than the other forms of unlawful conduct. You could have a sexual harassment complaint based on allegations of inappropriate conduct that may not rise to the level of illegal or actionable harassment.
But the retaliation
ultimately,
does.
That person was retaliated
Got
against.
it.
Read the EEOC stats every year, read the DFEH stats every year. More money is recovered in retaliation lawsuits than discrimination and harassment lawsuits. So it's very fair. As a matter of fact, when I do training with my clients, I tell them, this is the area of law that you need to pay attention to. And then I try to give them an analogy of go back to when we were in elementary school, and on the playground, Sally and Tommy got into a fight. You're the teacher in the classroom. They come in crying. You didn't witness it. What happens in cases like this is usually you have a group of fellow employees or fellow supervisors who support the person who's making the complaint, and then you have a group who supports the accused. And that's where we have trouble. Because if those individuals are very rooted in their defense of one person or the other, and they engage in adverse employment action towards the complainant or any witness who's involved in an investigation, we are in a retaliation situation. Now, is every workplace incident adverse and gives rise to a retaliation claim? No, we have legal standards as well, right? It has to materially affect and change the terms and conditions of employment, deter people from coming forth and bringing their civil rights claims and so forth. But that's the true reality of it if we just look at it from a human perspective, right? Is that you have two groups of people who are supporting two different people on two sides of a situation. So I agree with you. There's probably not a perfect world where retaliation will never be an issue. It's a very tough problem and one employers have to be committed to preventing.
And what have you found in culture, in policy, in practice that can mitigate that on the front end, if anything?
On the front end, I am a firm believer in bias training being a part of an anti-harassment program. I think a lot of us, all of us, as I said before, have unconscious biases. We walk through the world with perceptions and misperceptions based on what we view of people not like us, and so forth. And sometimes we're not even aware of it, but we're acting on it. And so I think on the front end, if we do some preventative training in the elimination of implicit and unconscious bias, we maybe can be a little bit more aware when an actual situation happens at work and not act upon it.
Couldn't agree with you more.
Mr. Morlock.
Thank you, Madam Chair. I've been to a few of these hearings now, and the more I listen, the more I realize that this is so much more complex than you would think on the surface. So I appreciate the term walking on eggshells. So for me, I want to address the creeps. You know, I want to get to the core and say, okay, who are the real abusers and take care of it. I was partner in a CPA firm. I never had an incident that I recall. I was department head for one of the largest counties in the nation. 75% of my workforce were female. Never had an incident. In fact, the EEOC officer we became friends, but I never had to deal with him on a professional relationship. But so I've been accused sometimes from friends for being puritanical and a prude at times. So we just kind of set a tone at the top all the time. But when I was chairman of the board in 2012, we had a creep. Senator Bates and I had to deal with a manager who, you know, is just remarkable what he was able to pull off until it came out. So I'm looking for the balance because now I am in a career where I am in a political world, and I know that candidates can be destroyed by whispering campaigns. And I have had plenty of campaign materials that said things that were absolutely false and that were not true. And I get, you know, then you got to live with that, and your family gets to live with it. And so I'm really concerned in the whole balance of this topic of false accusations, because we can manipulate. And I have watched certain things happen. I'm going, whoa, this is unbelievable. What can be done on the other side of the equation? So I'm really concerned about that, because as an elected official, you will be page one, senator accused of, and then you will be investigated, and then you will be found that it's not true, and then you will find that the newspaper on page C23 will say charges dropped. You know, so you don't get front page charges. You get, you know, it's like, this is so wrong. And so I want to try and make sure that we address malicious intent. So are there, besides suing for defamation, are there other remedies? Are there criminal charges? If you lie and you falsely accuse someone, are there criminal remedies? Just as, because you've now created a different kind of victim, right? So now the accused is the victim when that person may have done nothing at all, but it's just part of an attack because they don't like the policies or the politics, you know, of that person. And so I'm just curious how we bring the balance in here so that we take care of the creeps, but we don't have all these scarlet letters that follow people for the rest of their lives when they were innocent.
Yeah, I appreciate that concern. And unfortunately, I don't think there is a high percentage of truly malicious, fraudulent claims being filed. That's not what we are hearing in the news. I don't believe that's what you're experiencing here in the legislature. But I will tell you that it's not uncommon to have the isolated, ill-motivated, malicious, fraudulent claim made for ulterior reasons. And it should not change the approach to investigating that complaint. And a good investigator, through credibility assessments and evidence gathering, hopefully will get to the bottom as to whether there's reasonable suspicion that this is a fraudulent claim. There is case law to support that if there is a determination made that a harassment complaint is made fraudulently with malice, that appropriate disciplinary action up to and including termination can be had. So from an employment perspective, but I wouldn't cross that bridge quickly, right? I mean, I would really make sure that we have a credible, objective finding that this claim was brought fraudulently. If so, though, there is case law to support that the employer says, look, you know, you're out of here, right? That's what you can do as an employer. As the person, as the individual who had those false allegations made against him or her, your redress really is in our legal system. It is through the civil claims that you may have. There are employment attorneys who have now started to make that their specialty, one of which is actually in our region here, and he's very good at it. But it is a civil remedy, not a criminal remedy.
One of the things that I've seen as it relates to concerns of allegations as well as addressing retaliation is prompt investigations. I have a case right now I was just arguing in front of the California Court of Appeals yesterday where the investigation took 3.5 years. 3.5 years. I got my law degree in less time than it took the state to investigate a simple issue in the workplace. And so that cuts both ways. It gives the message, we don't care and we don't want your complaints. And so if you're going to complain, it's going to go into a hole and there's going to be no remedial measures. Now, if on the flip side, that the person for whom the complaint was made about, they have an outstanding complaint against them for 3.5 years. So that, of course, is one of the worst I've seen in representing public employees for 20 years. You don't want to have an investigation go on for 3.5 years. But that it is going on, and I think having a prompt investigation is key to addressing some of these issues in real time in order to encourage the kind of workplace that you want and discourage concerns, whether those concerns are validated by statistics or not, the concerns about some sort of false reporting, which again, I think false reporting, as indicated by my colleague, is really statistically not an issue.
Well, I appreciate.
I'd just like to echo my fellow panelists in saying that I think our focus should be on fair processes, prompt processes for handling claims, and that benefits both those on both parties. That should be our focus, and that I think we're dealing with situations where it's much more likely that somebody will report and not have their claim taken seriously. That is the real concern right now, as opposed to false accusations. But that both circumstances, a fair process by an independent, neutral entity that reacts promptly benefits everybody.
Thanks, because Ms. Mizell, you at least mentioned the issue of prior complaints, so that if you've got one, but if you've got 4 or 5, or in Weinstein or Toback, you got millions, that's the creeps. Those are the creeps I want to take care of. I want them out of the system, but I don't want someone being the victim of a false complaint. So I'm just trying to find the balance. So I thank you for coming today and answering my questions. Thank you, Madam Chair.
If I could just piggyback on that for a second. I was a council member in a city before I came here, and I certainly saw times when, and you talked earlier about settlements and about having people that were accused sometimes pay settlements, but I had definitely seen times when at least cities paid claims against them as settlements to employees that they felt they might not believe, they might have been inclined to fight the charge or go to court, but instead of even investigating things like workplace harassment complaints, they decided to settle. These were employees who had left, who were then going to bring civil lawsuits forward, and decided to settle just because of doing a cost-benefit analysis and thinking that it was just less expensive for them to settle a case than to take it to court or to even launch a formal long investigation. So how do you, now I understand somebody coming forward with a workplace complaint is different than filing a lawsuit, but does that, if we're going to make every settlement public or make members or employees pay for settlements, wouldn't that then say that you would basically stop doing those sorts of settlements where, I don't know what you call them, I'm not a lawyer, where sort of everyone, they say they're not at fault, but they're going to pay the claim, and you're settling a case rather than going to court and having it go through the court system and then resulting in a judgment? How does that impact the desire to settle versus the desire to take something to court to adjudicate it if you're going to then make the accused pay that settlement or make the result of a settlement public, even if there was no investigation finding someone at fault?
Well, this body has a particular, the rules relating to public settlements are different for state entities because it's taxpayer money. So the taxpayer has a right to know where their money is being spent. I have been representing public employees for 20 years, and when I'm presented with confidentiality clauses as it relates to the state entity, my response is this is state money, and the taxpayer has the right to know where that money is going. So that's one thing. I think there's some limitations as to whether you can have private or confidentiality clauses, and I question about the public policy implications of allowing such policies to exist. I think it's against public policy, and I think it encourages additional unlawful conduct to happen. If you have secret settlements and gag clauses, that's what allows these things to flourish, as opposed to having public about these sort of settlements. And then the second issue.
But just to clarify, I wasn't implying that the settlements are secret. I'm saying that they're done with sort of a no-fault clause. So if typically a city can settle a workplace claim by coming to an agreement with an employee or an ex-employee to pay a certain amount of money, saying we're not at fault, we don't believe that we're at fault, but we're going to pay this claim because it's actually less money for the taxpayers to pay $25,000 than to take it to court, and who knows what's going to end up happening. So I'm wondering, and I've never seen one with a sexual harassment claim, but I have seen that done with workplace discrimination claims brought to different municipalities. It's not that uncommon. I mean, it's not that uncommon. So how would that impact then if we're going to ask the person who was accused to pay that claim?
Well, currently under the law, the legislature or for public employees, the individual is indemnified unless they've acted outside of the course and scope of their employment. So as the law exists today, the state does not have to pay for either the defense or the costs if they make the determination that that individual is acting outside of the scope and course of their employment. Now, employers do indemnify, and there's a strategic reason for it. They want to control the harasser and the alleged harasser and defendant, because if you have that person going out on their own and making statements in the lawsuit, they could say, yeah, I did it. And then there's liability for the employer. So that is a strategic decision. That's not a decision as a matter of law. The tools are already there that a state employer can decide they're not going to indemnify and they're not going to defend. That already exists. It's just that as a strategy decision, they choose to do so. Additionally, as a matter of law, punitive damages are not paid by the state. You cannot obtain punitive damages by the state. So even if you choose to indemnify someone who is found to have been a harasser, you don't pay, the state doesn't pay those punitive damages. Those would have to come out of the pocket of the harasser, which I think is fair.
Well, I want to make sure that I'm addressing directly your question, because also in the private sector, the accused, while employed, is subject to indemnification or entitled to indemnification under Labor Code 2802 until there is a determination made that the harassment did in fact occur, because that is considered conduct outside the course and scope of employment, and therefore the employer does not have to indemnify. As for the motivation for employers entering into private settlements in lieu of protracted litigation, there are many different motivations for that, one of which could be the pure cost and time involved in litigation. Our courts are very impacted. These cases go on for years, and if in fact you do end up in front of a jury, you're not always sure who that jury is going to be and what the risk is. Other motivations are, we in fact need to resolve this because this is bad, right? This should not have happened. We don't have legitimate defenses taking this to trial, so we should get it resolved. So there are many different reasons why, but oftentimes, I believe what you were referring to, Chairwoman, was just the decision to have a settlement with a non-admission clause to get this put behind us. And so if we enter into these, but yet we turn around and we publicize them all or disclose them because we're a public body to the public, how does that help in any way versus just going to trial and it being public? I think you've got to determine what are the reasons why an early settlement is better than a protracted litigation, too.
Ask for patience from my colleagues who I know have questions, and ask the panel if you can stay for a few more minutes. But we do have a panelist who has to leave because she's catching an airplane. So if you don't mind, I'm going to call up Ann Revel to make her comments and answer any questions, and then we're going to ask you to come back up, if that's okay. And I will ask my colleagues for their understanding. We'll come back. Ms. Ravel. We'll let Ms. West go so that she doesn't have to, I'm sorry, not Ms. West, Ms. Johnson leave so that she doesn't have to stay staring at a screen. But thank you very much for your help today. It was very helpful.
Thank you. Thank you for this opportunity.
Madam Chair, I have a class to teach. So thank you for taking me a little bit out of order. My name is Ann Ravel, and I'm the former chair of the California Fair Political Practices Commission, as well as the Federal Election Commission. And I am here not to speak about sexual harassment per se, but to address some of the issues that have been raised relating to the enforcement of matters against public officials. And I frankly believe that, and I have done sexual harassment work when I was a lawyer for the county, but I do think that the legislature is unique and that how to address these issues is a little more complicated than as a regular employer. And for the reasons that have been raised, many of them, because obviously the desire to protect the victim or the alleged victim, to ensure that there is a fair process is the same no matter what, but there is unique aspects of individuals who are in a political position and how press and other information that comes out is being used against them. And for that reason, I think you have to look at, and this is, I think, why I've been asked to speak, I think you have to look at what might be a better process rather than a regular employer who might have an internal process. So excuse me, if you, it seems to me that there's a number of ways to look at these complaints. One of them is just to hire an investigator and a lawyer, which I think people have referred to today, which I do not think is probably the best way. There's also some bodies have a specific individual, like an IG, who would be the person to oversee an investigator or do the investigation themselves in a separate body. I'm sorry, an inspector general. And some commissions, like the FPPC, actually in other states actually only have one commissioner and investigators. But frankly, having seen both the Federal Election Commission and the California Fair Political Practices Commission, my view is that that is a really good mechanism for reviewing complaints against elected officials, whether it be for violations of the Political Reform Act, as that is, or ethics violations, which the FPPC also has authority over, or something like this. And the reason for that is, if you look at the composition of the FPPC, it is specifically bipartisan, and it is intended to be nonpartisan. And, you know, this is not Washington, D.C. I understand that. Happy to be back in California where it is not. But nonetheless, there are political aspects to these issues, no question about it. So having a bipartisan commission is a really good alternative to having one person who may be appointed by somebody of one party or another. The other aspect of it is that because those commissions are totally independent and act independently, do not report to the legislature per se, except insofar as they have relationships, and they should, to do training, to try to change the culture, as you spoke about, to get compliance ahead of time rather than focusing solely on punishment. And while, of course, there's that ultimately has to take place as well, the enforcement of the law, but really those kinds of organizations tend to see their role in many ways as trying to work with the body that they are there to oversee, in the sense, to get voluntary compliance, to change the culture so that it's not purely punitive, but it is about education and about how to interact pursuant to the law. So this is why, in some ways, I think that model is a good one. And for those of you who don't know, I mean, and there are probably lots of different ways of setting it up legislatively if you were going to pursue something like this. But the FPPC, the appointments are, each constitutional officer has an appointment. And if there are, as in the case of California, only one party as constitutional officers, then some of the appointments must be made, in this case, by the Republican Party. And that provides that balance and that sort of check on the authority of the commission, which then oversees the investigators within the agency. So that independence, I think, is a really good thing, because what it does is it requires, unlike the FEC, where it was a body of 6, and the essential appointees were either the majority leader or the minority leader of the Senate. And as a result, there was some sense that they were beholden to those individuals. So they essentially became much more political. And I think you have in front of you my report that I wrote before when I left the FEC, and it certainly had an impact in enforcement at the FEC. But some of the things that have been spoken about by the previous panel are also really important, because clearly the ability of such an independent commission to act is also dependent on the fact that they are provided ample budget to do so. And in many commissions nationwide, how the legislature or local government manages to assure that there is no actual fair activity of those commissions is that they are starved for resources. So resources are really important for both aspects, both for the education, the advice aspect, which should be a component of it, but also for the enforcement and investigation aspect. It's really important that there be sufficient resources. So the other thing is, as is true of the FPPC, the commissioners can't be removed during their terms, so there can't be any retaliation or any actions if people do not agree with their actions. With regard to the investigations, and I do think it's important to have investigators that then make recommendations to the commissioners. And I absolutely agree, they have to be timely. I think that's been said before, but that is really, really important no matter what the context, but in particular in sexual harassment matters, they must be timely, and I would suggest that any rules relating to such a commission would have targets for timelines, not necessarily requiring them because some things are more complex than others, but targets are really important, both for the victims as well as the accused. And I also think that the investigative process itself, and I may differ from what some of the others on the panel prior have said, I believe that the investigative process should be totally confidential. And I do not think that unless there is a finding that there is valid belief of sexual harassment having occurred, that there should be publicity surrounding it. I think that it is so important, and I saw this at the FPPC, just the allegation, just the statement, just a complaint being filed, and you can't stop people from publicizing their own complaints, but just that complaint is enough for people to have an adverse view of the person who is being complained against. And that, I think you said, we know that's on the front page of the Sacramento Bee or whatever hometown newspaper, and then the decision where nothing is proven is usually hidden somewhere in one paragraph, or maybe not at all. And so I do have concerns about having publicity, and I am a big believer in government transparency, without a doubt. But sometimes these cases can have consequences that are really unfair, and I think that the process, let me just say, and I think I mentioned this to your staff, when I went to the FPPC, there was a listing on the website of all the complaints that had been filed. And so it raised the notoriety of it, which I do not think that an investigative agency should engage in. The investigative agency must ensure that the process is fair to the victim, alleged victim, to the alleged perpetrator, and once a determination is made, then publicity is fine, not a problem. But prior to that time, I do not think that it's appropriate. So I also think, I mean, I understand why accusers, there was a question about anonymous accusers. I understand why there would be anonymity, no question. And there has to be protection for the accusers as well. And so it's important that there be some kind of a flexible investigative process so that the rights and the privacy of the accusers are protected, but with cognizant understanding of what the rights and privacy needs of the people who are being accused as well. So with that, I don't want to take too much of your time, but I'm more than happy to answer questions.
Thank you for being here. You know, are starting to, the panel is starting to move from identifying problem, looking at issues, and also into potential solutions. So this is, you know, a very interesting area, and there's been a lot of suggestion and a lot of thought amongst us about bringing an outside entity of some sort in or creating one in-house, and how you balance the governance of this body having been from within the legislature to looking at these outside, not just investigators or advisors, but the FPPC is also an enforcer. And when it comes to campaign finance and it comes to certain types of ethics violations, we don't police ourselves. We do have an outside body that does that, which has some challenges, but also is, in my mind, a much fairer way for everybody of having that done, because people have said, well, the legislature is incapable of policing itself, but I would also submit that it's unfair to expect colleagues to police other colleagues, and I don't believe that in the private sector we ask people to bring their equals in if there's been a workplace issue and then vote on what happens to them. You know, the law guides us and guidelines guide us. But I will also say that we're talking about issues that are very much workplace issues, about how people work with each other, which is different from a campaign issue or another type of ethical issue. So how would you judge that? Would you anticipate, because clearly you've thought about this, a process where rules and human resources deals with issues that they can deal with, but when things sort of hit a certain threshold that we all understand of crossing an ethical line, that they would then bring the FPPC in, or would employees go directly to the FPPC when an allegation involves a member? Have you given that any thought, or do you think that that's all kind of to be determined?
Well, I think it could be determined based on what the legislature obviously feels is the most comfortable. I don't think it's a question of what's the best, or either way would work, although certainly an agency such as a FPPC would be suited to do that, because some of those issues, as you mentioned, ethics issues, some of them can relate to workplace issues too. And so FPPC already has a group that is set up to investigate cases. And obviously, these do have a little more sensitivity, and they probably would require more witnesses than what normally is done through FPPC investigations. But an outside agency could do all of the above and make it a lot more, maybe a lot more independent, just in general.
So you would anticipate, or what you're thinking is, in the same way that when there are sexual harassment claims against members, the legislature currently hires outside investigators. You would say that the same thing would happen. It's just that the responsibility of that oversight would shift to the FPPC to basically hire sort of the same, from the same, I would think, limited group of investigators that are there, and then the decision that would be made as to what the, whether or not, after an allegation sustained, then the penalties would be either suggested by the FPPC or actually enforced and sort of handed down by the FPPC?
Right. Well, what the FPPC does as a commission is there are times that they would look at a recommendation from the investigator and say, either we think that there is an error in the judgment and that this is not a matter that is actually sexual harassment, or the reverse. So the commission would exercise independent judgment in that respect with regard. It's not common, but it happens. It does happen that not only do you make the decision at the commission level as to what the penalty should be, but sometimes you don't agree with the investigator's assessment of a particular case. The other aspect of it is that the FPPC can do while they're overseeing the investigators is to determine, which is something that was always on my mind when dealing with the enforcement division at the FPPC, is whether either they are being too lax or being too onerous. And so you have to look at patterns of the investigators to be able to actually assess whether or not they are being fair and unbiased as well.
So you would come back, then the FPPC would come back with a finding based on an investigation that they oversaw. But then what would the penalties be? Because typically with a campaign violation, there would be a monetary penalty. Sometimes there could be a criminal penalty. But when it comes to sexual harassment and the violation is against an employee in the legislature, how would the FPPC then resolve that?
Right. Well, that would have to be part of whatever legislation is ultimately enacted by the legislature as to what they think that the range of what the range of potential penalties should be. And according to, as one of the previous panelists talked about, dependent on what the violation allegedly was and what is found, to make sure that it's commensurate with whatever that is. So definitely there would have to be new rules, new laws that would govern such a role for the FPPC, if that's who it was that you chose, as opposed to starting an entirely new commission.
And we've talked here about having more objective criteria about what penalties would be for legislators. And just to clarify, when you mention a commission, are you talking about the FPPC itself or a new commission that's just for sexual harassment?
It could be either. It could be either. I mean, it's probably convenient that it already has a commission process set up, although obviously I would guess that most of the people who are presently on that commission are people who are particularly interested in political law, perhaps, or issues related to government ethics. And so it might be a different group of commissioners that might be better suited to handle cases such as this.
But there could certainly be counsel who guides them.
Yes.
Who is, expert in this type of law. But you're absolutely right that the penalty part is something that, has been brought up to us many times of there being a lack of clarity for members and for others about what penalties are, what's allowed under the law. And in the past, penalties have ranged from people having their committee chairs taken away to a talking to. Okay. Now, the other question I want to ask you that's going to relate back to your own unconscious or conscious bias, which is that people, as we've been going through this process, have suggested a lot of different entities to do this role. We've heard suggestions from the auditor to the attorney general. County of Los Angeles has an internal process for their own promotions that involves 9 civil law judges who are then impaneled in 3 by 3 to make findings and recommendations to department heads. So there have been a lot of different suggestions about if we were going to do this, what's the correct body? I served on the Metropolitan Water, Southern California Metropolitan Water Board, and they had an internal ethics officer who was independent who did this role. So have you given thought to, given your own unconscious bias of having run the FPPC, whether what the strengths and weaknesses are of other bodies as opposed to FPPC.
Right. Well, I, with all due respect to judges and retired judges, many of them are not, while they're in government in a role, they're not that sensitive to some of the issues that we're talking about here today. And so I'm not sure that it would be the right body to handle such a thing. I'm not familiar with the AG's office internal ethics person, but my concern about that for the legislature might just be that that person, while they're independent, they're in an executive branch office with an elected official who is the head of that office. And that may pose problems for the legislature as a whole. They might be concerned about some political bias with respect to that particular office. But that's a judgment for you to make. But for me, from what I've seen nationwide, not relating to these issues, of course, but independent, truly independent groups tend to be very cognizant of balancing all of the interests in trying to be absolutely fair.
Great. With that, I'm going to see if any of my colleagues have any questions for Ms. Ravel while she's here. Yes, Ms. Bates.
Thank you, Mr. Ravel. I think what you did for me in your testimony, you really addressed the balance issue that we struggle with in terms of transparency and accountability to taxpayers. Clearly, FPPC already has that responsibility. Bringing up the issue of a new law so that we can deal with the levels of accountability and penalties is probably the biggest problem that we've got as a commission. Where do we go with that? So I appreciate your very thoughtful comments. I think most of us as elected officials have had some interaction with FPPC. I will say that in my own case many years ago, the timeliness of it failed, and I was really affected for a number of years by a judgment that was finally ruled erroneous, but it took 3.5 years and affected certainly my business at that time. But, you know, people and accountability and mistakes happen, and mine was corrected. But I think in this instance, something that took that long to adjudicate and then find someone innocent when they were perceived as guilty for that amount of time is horrific. It's horrific to their career path as young people. It's horrific to people who are in this for a short period of time because of term limits and must return to their former career. So we have to be extremely mindful of that as we go forward, and we come up with that level and list of consequences and how that will be handled. And I vote, and I'll make it very public, I vote for total confidentiality until there's a ruling. That's what we have in the courts, and that clearly is what should be something that we all embrace here. So thank you for bringing that perspective forward. I think it was long overdue. Thank you.
But I agree with you. I can't emphasize enough how timeliness is so crucial in these matters, and admittedly, the FPPC has not always had a good record in that respect, but it's certainly something that I think is important, and that's why any legislation, if that's what you determine that you're going to do, should include targets for timeliness.
And my issue is a conflict of interest as a mayor of a city, and whether I did or didn't have one, and it was all very speculative, and a lot of people, because of other issues going on, were attacking the whole council at that time, but it took that long, and those are things that we have to be very mindful of here.
Right.
So thank you.
Other questions from the panel? Okay. Thank you, Ms. Ravel. Really appreciate your coming.
Thank you for taking me out of order.
Thank you.
I appreciate it.
So I'm going to ask my colleagues, if you have questions for the previous panel, they're waiting patiently. Should I bring them back up? Sure. Okay. Great. And we do have one more speaker, but why don't we finish with the questions with the previous panel, and then we'll bring our last panelist up.
Thank you, Madam Chair. I wanted to comment on, what, are we okay? Okay. Thank you, Madam Chair. I wanted to comment on what one of our colleagues said, Assemblymember Dolly, about at-will employees. And really, there's a way to fix that. If we want to organize the workplace, and when workers are under a union contract, it fixes a lot of what ails us in the workplace, because the employers know what they can and can't do, and the workers know what they can and can't do. So I just throw that out as something that we could look at. I want to talk a little bit about retaliation, because I think retaliation is incredibly real for every single person who is not elected that works in the building. And this is, working here in the Capitol is not like working in any other profession. If you are blackballed, if you are retaliated against, where do you go and get a job? And this might be, just because you're not the elected, you're passionate about public policy. You're trying to make things better. I know I couldn't do my job without my staff. So I think we really have to think about retaliation and how everyone here worries about that, and they're fearful of that. I investigated grievances for 20 years when I was in the labor movement, and we used to say that there's two sides to every story, and the truth lies somewhere in between. And it's not ever because someone's actually lying. It's usually, sometimes people are lying, but usually it's because people just remember things differently. So sometimes investigations might take a little longer because you have to talk to a broader base of people. And I think we should always do that. Ms. West, I wanted to thank you for bringing up that we should never put a time limit on investigating, because what I've heard throughout the last months, some people have said, oh, well, why is this coming out? It happened so long ago. Well, it's because as people come forward, and especially as so many women have come forward, it makes another woman feel confident enough to come forward. So we can't ever say because it happened 5 years ago, 10 years ago, that it's not valid. I think about the statute of limitation on rape bill that we passed out of, that the governor signed into law a couple years ago. You can't put a time limit on justice, and everyone here saw that, the governor saw that, and I think we need to make sure that we're looking out for staff, that we're taking care of them. There are 120 of us that work here in this building, and I always say it's kind of like 120 little privately owned businesses, because we're all a little different. We all come from different walks of life, but we have to worry about the staff who work here, because when I'm termed out, many of my staff still have a career ahead of them, and they will want to go work for someone else. So I just put that out there to make sure that we're cognizant of those who really help us here in the building and the ones who can be most taken advantage of. So we have to have policies in place to protect them, because all of us electeds are different, and we all come from a different place. And if you did not have a staff before you were elected, you may not know what is okay and what is not okay to do. So I hope that we will continue this, and we will get to where we need to be. Thank you.
May I respond, Madam Chair? I stand firm with my belief that the one-year time limit in the policy should not be there, that all claims of harassment should be investigated. But I think there's a counter argument or balance to that. One, I think we want very, very strongly to encourage people to report right away, very quickly, for a number of reasons. One, so we can stop the conduct, stop it from escalating. Also because, as you just indicated about perceptions and memories, the longer time goes by, memories fade as to what did or did not occur. So while I don't think there should ever be a time limit on investigating a report of misconduct in the workplace, again, if they bring something forward that happened to them years ago, other conduct could be happening to them and others within that time period, as my panel member indicated. But also, we need to address things quickly, and the longer the time goes by, the harder it is to really try to make a reasonable determination as to what occurred.
If I may, I could not agree more. We want people to come forward, but that's on us. That's on us making sure that we put in place something that makes people, that employees in this building, staff in this building feel safe and that they feel like they can come forward. Because I agree, I don't like to see people sit on things, but I understand why it happens. So it's on us to try and find a way that we make it a safe environment to come forward.
And I think you've taken the right step with the recent whistleblower bill that got signed, yes.
Thank you. Ms. Reyes?
Thank you, Madam Chair, and thank you, panelists. The area that I would like to speak a little bit more about is confidentiality. There was a statement made that reporting is the victim's choice. I agree. But in the end, after the victim has chosen to report and it is investigated, the issue of a confidentiality clause for the protection of the victim, is that something that, I know that you have strong opinions regarding this, because, and you've mentioned that it has to do with public policy, transparency, and I recognize all of that. If that is something that the victim is asking for, under what circumstances, if any, would you feel that that would be appropriate?
So I also wanted to address that Labor Code 232.5 allows and actually mandates that there cannot be limitations on discussions about terms and conditions of employment. So that's a law that already applies to this body. And so I wanted to raise that. It also, the NLRB had a decision about concerted activity. And so if you're going to gag information flow during an investigatory process, you really have to question whether that's in keeping with current legal standards. So I wanted to address that first. Secondly, I think confidentiality clauses are gagging the victim. That's what they are. And do we, as a body, think that as a matter of public policy, we ought to be gagging victims? And I would say no. There's many reasons for this. One is it continues the conduct, the unlawful conduct. It certainly doesn't bring it to life. It certainly doesn't lead to any adequate remedial measures. So I think as a matter of public policy, we should have limitations regarding such clauses, which are ubiquitous. Employers ask for these as a matter of course, whether it actually benefits them or not. They may wish to have their story come out. They may wish to say, you know what, that's not how it went down, and we took this as a business decision. But if the ubiquitous nature of confidentiality clauses prohibits that sort of public discussion, and I think what really happens is the victims are the ones that are gagged. It's not the employer. So that's what I find in my practice, is that if there's a confidentiality clause, it's really the woman who can't tell her daughter, don't go work for that member, don't go work for that employer. It's the woman who can't discuss it with her therapist. I mean, these are against public policy, and I think those things have to stop, not only in the one-on-one interaction of gagging someone who's been the victim of a crime. We don't say for homicide victims, you have to be silent. The family members of the homicide victim, it's the same thing here. This is a crime, and we certainly shouldn't enable a crime by keeping it silent. I think the silence is part of the problem. So yes, I do have very strong feelings about it. There are some individuals who may choose, because they are afraid of retaliation, not to come forward. I have, again, clients who regularly receive press calls and they decline them. And there's reasons for that. And I think that sort of choice should lie with the survivor. But I don't think it should be as a matter of law. A survivor of harassment can keep things confidential by simply not speaking about it, but not being mandated by law not to speak about it. So a very simple solution, you just don't talk about it. But allowing those confidentiality clauses to persist, I think, creates those systemic problems that we're dealing with today.
Now, along those same lines, I'm sorry, I don't recall who it was that talked about it, about the victim's ability to go straight to Weave and to have that as a protected activity, I believe it was you. Tell us about why that is so important, that it be a protected activity and therefore cannot be retaliated against.
Yes. So while I think it's a very good step to allow resources for individuals who've been subjected to harassment, discrimination, and retaliation to be able to go somewhere to obtain those sort of resources in order to get things like therapy. But if as a body you're saying you can go report to agency A, but we don't consider that report a protected activity, what the legal ramifications of that is if there is retaliation in the workplace, that is not considered a protected activity such that that victim then can have legal remedies if they are subjected to retaliation. Additionally, it doesn't allow this body to look at, well, why are there these complaints coming out of a certain member's office? How can we stem that tide? Are those valid complaints, invalid complaints? So it doesn't allow this body to take adequate remedial measures to address it. So I think it's a wonderful resource. I'm very happy that it's in place, but I think it needs some tinkering to allow it to be a protected activity, or to say very clearly, if you go to Weave, you're not protected by the law. You may get a resource, and that's wonderful. And you may get resources to deal with trauma, you may get therapy that you need, and that has its own value, but that needs to be stated up front that that has certain legal consequences and allows the person in that situation to decide, do they want to make a complaint and be covered under the law for protected activity, or do they want to get therapy and not talk about it again? They can make that choice, but they ought to know the choice they're making.
One of the comments, thank you so much. One of the comments had to do with keeping the investigation confidential until there was a finding. It goes to the very purpose of our judicial system, that of due process. If you are being investigated, that doesn't mean you have been convicted. You are being accused. How do you balance that? How do you make sure that you do keep these investigations confidential during the process so that you do protect both the victim and the accused?
I think this already exists under the law, meaning if I've been the victim of a sexual harassment in a member's office, I should be allowed, and legally I am allowed, to talk about the terms and conditions of my employment. That's different than what did I say on X day to the investigator. It may be the exact same circumstances, but there's a delineation there that I think is very important, because if I'm saying I reported X, Y, and Z to the investigator while the investigation is ongoing, that could affect other witnesses' statements. Talking about the exact same circumstances, because it is the conditions that exist in my workplace, that's legal under Labor Code 232.5, as well as under the NLRB decisions. So I think wanting to tap down all discussions about the terms and conditions of employment is illegal and is separate and apart from what's happening in an investigation.
If I may, I do think I touched upon this as well as counsel for employers and as a neutral investigator from time to time hired by other employment lawyers. It is imperative that the integrity of an investigation be protected. And part of that is to keep confidences, for people to use discretion and judgment with respect to who they talk to when the investigation is ongoing, for the very reason that we don't want stories of witnesses to be influenced by other witnesses, and for the very reason that we want the investigative process to go forward towards a reasonable conclusion based on whatever the burden of proof is. In our world, it's the preponderance of the evidence. Years ago, as my panelist, my co-panelist has indicated, we got a very strange ruling from the NLRB in the Banner case, which essentially said that the longstanding tradition of independent investigators giving witnesses in investigations an admonition that they should keep what's discussed with the investigator confidential, so as not to run the risk of the integrity of the investigation was a unlawful practice under Section 7 of the NLRA. That has become a very difficult decision for independent workplace investigators to grapple with. They didn't say that you couldn't give any admonitions to witnesses in an investigation if you could identify actual tangible risks of other witnesses being influenced. You could give that admonition. You should not talk to so-and-so because we believe that there's a risk. But the general overall statement of please keep things confidential, use good judgment and discretion, the Banner case said was a violation of Section 7. I agree with my panelists that employees under the Labor Code have a statutory right to talk about the terms and conditions of their employment, but I do still believe that in an investigation, we want to keep things as confidential as possible, protect the integrity of the investigation until we have a determination that, in fact, misconduct and harassment has occurred. We are dealing with allegations. Everybody has a right to participate and be heard.
Finally, Madam Chair, I think it's clear from the testimony that we've received that we're looking at balance. We want to be sure that at the very top of the list, that our victims who come forward, who are brave enough to come forward, that they are protected in every way that they can be protected, and that their allegations are investigated properly so that we can come quickly to a solution. It's clear also that the accused, we do have due process, and we do have to remember that there has to be a protection for those who are accused, and due process is part of what the fabric of our judicial system. The employer has great responsibilities. We've talked about strict liability, and that's something that we have to be mindful of. But I also want to appreciate the comments that were made regarding our responsibility to the public. The public pays our salary, the public pays the settlements, the public is absolutely has the absolute right to know what it is we're doing. We do want to protect the public, but the public does have a right to know. So I really appreciate all of your comments, and I do want to thank you for that.
Thank you. AB 403 allows the legislature to determine which groups are going to be have protected disclosure, and I'm going to direct staff to look into making it clear that would be one of those sources for protected disclosures. So I really appreciate you bringing that issue forward, and we'll make sure that we begin that process. Does anybody have any last questions for this panel? Thank you very much. This was very revealing, and I very much appreciate your time. Thank you.
Thank you very much.
And with that, we're going to bring up our last panelist, Kathleen Reardon. To be have protected disclosure, and I'm going to stop to look into that, making it clear that we've would be one of those sources for protected disclosures. So I really appreciate bringing that issue. Sure that. Are you there?
Yes, I am.
Oh, terrific. We can hear you very well. Thank you so much for joining us today.
Well, thank you for the invitation. I appreciate it.
Okay.
Right.
You're on, literally, here in the room.
Okay. Well, I have been listening, and I'll be talking from a different vantage point, and that is largely bringing my communication peers, communication and gender issues to bear on how we talk about gender-based offenses. And I call it that because there are differences, not distinct, but differences, you know, between types of behavior. We know that. We know that there are differences in terms of various levels of kindness, for example, or various levels of generosity. Well, similarly, there's differences, different levels of gender-based offenses. And I think as leaders yourselves, to the extent that you have kind of vocabulary to use with your constituents as well, that it really facilitates their understanding of what
what it is that you're doing, what you're working to do to protect both the person who is accusing or who is a complainant, or the person who has also been accused. I heard today that you are, of course, naturally concerned about both. And we're in a period of time right now where there's a great deal of. Am I coming through clearly enough?
Just give us one moment.
Okay. Okay. Right. Okay, so, all right. What I'm here to talk about is okay. Yeah. All right. Now, can you hear me now? Better? Okay, great. I hope you're not too hungry at this point, too. But I'm here to talk about the levels of misconduct. Right? We've heard that there's zero tolerance. We need to have zero tolerance, but we have to define zero tolerance to what? And so, as you know, I can see that it's not going so well, that you can't really hear me very well.
It's better now than it was. So if you just speak slowly and a little bit louder, we're doing okay here.
Okay. All right. So when we speak of zero tolerance, we need to speak about zero tolerance to what? And right now, a lot of the fear that has been discussed today, and also levels of retaliation that I'll speak to in a moment, all of these things are related to how we look at sexual misconduct, what it is. So what I did was develop a working blueprint for organizations to use as well, to begin to talk about what are the different types of offense. You know, we offend each other all, but levels of offense are much more serious than others and deserve different kind of penalty, as was mentioned before. Just a talking to, or is it some kind of suspension, or is someone asked to leave? So if you look at.
Sorry, I'm going to have to interrupt you. It's not, the sound is not coming through adequately, I think, to really have this conversation. So if you'll excuse us, I really appreciate your having sat through all of this. We're going to try to find at an upcoming hearing a way to bring you back in. Maybe it's even pre-recording your testimony and playing it and allowing us to ask questions. But I want to make sure that everything that you have to say is heard, and we're not able to do that right now with this technology. So I'm going to, ask your patience, and thank you very much for being here with us. We're going to have a discussion offline after the hearing about how the best way to get you back here to give us the information.
Okay, well, thank you very much. And if you have a chance to look at the spectrum yourself.
Yes, and it is very helpful, and we will look at that. And, again, we will have a conversation about ways that we can have you testify with us by voice. But right now, it's just not happening appropriately.
Madam Chair, may I at least thank her for her spectrum of sexual misconduct at work. This handout is very helpful. So I just wanted to thank you now that.
Yes.
I do wish we were able to talk about it as it might be helpful in.
Well, we do have the spectrum of sexual misconduct at work, and we'll take a look at it, and it's also available for the public to see. And we will have a conversation, I think, at a future time about that as well, as we start to incorporate what our policy is and trying to outline a little more specifically what we feel different penalties would be for different types of transgressions. This will be very, very helpful. So thank you so much for providing that to us.
Okay.
Thank you. With that, I'm going to go to my colleagues to see if there's any closing comments from anybody.
Cool. Public comment.
Oh, and public comment. Is there any member of the public? Yes, please come up to the microphone.
Hello, I'm Sabrina Brennan, a harbor commissioner in San Mateo County, and I'm speaking today as a member of the public. I can tell you from personal experience that complaints and investigations at the countywide special district that I'm elected to represent are severely mishandled. Thank you for your service and for the opportunity to make the following remarks. There should be uniform anti-harassment, anti-discrimination, and anti-retaliation policies, laws, whistleblower protections, education, and training across state and local agencies. In-depth anti-harassment, anti-discrimination, and anti-retaliation education and training should be a requirement for all elected and appointed representatives and government employees. Currently, training lacks information about best practices for conducting independent investigations once a complaint is made. All harassment, discrimination, and retaliation complaints should be investigated, and the findings should be transparent. That's not currently the case. Types of inappropriate behavior should be clearly described, and consequences should be well defined. Doing this would help move cultural norms in a positive direction. Investigators should be selected by a panel of 3 or more people, and the panel must include both women and men. This is not currently the case for special districts, city councils, and other local agencies in many cases. The complaint and the complaintee and the complainant should be provided with copies of all investigation reports. This is also not the case currently. Recommendations about disciplinary action should be made by a panel or a review board that includes both women and men. A commission or a statewide elected board might be a logical option for reviewing investigations and determining outcomes. However, my experience with the FPPC would not lead me to believe that they would be able to do this in a timely way. I'm adding that just based on the testimony that happened today. An appeal board could review decisions in the event that a complainant or complaintee was dissatisfied with an investigation or an outcome of an investigation. Recently, I've been in conversation with Neil McCormick, director of the California Special Districts Association, about the need for anti-harassment, anti-discrimination, and anti-retaliation training, and I think bias training is also equally important, that includes best practices for conducting unbiased and independent investigations. There is no training like that currently. However, I'd like to point out that it's not reasonable to expect that local agency associations like CSDA and the League of Cities or an overburdened state oversight agency will be able to correct the long history of sexual harassment, gender discrimination, and sexual orientation discrimination in the workplace. And it's worth noting that many of those organizations lack gender diversity, racial diversity, and sexual orientation diversity in management positions, organizational governance, consultants hired to provide training, and newsletters, websites, and social media content. This pandemic has been overlooked for far too long. A comprehensive statewide plan for addressing these complex problems must be thoughtfully developed, prioritized, and funded. It's critically important that workplaces throughout California be safe and free from harassment, discrimination, and retaliation. I applaud your effort to search for creative solutions. Thank you.
Thank you very much, and I totally agree with the speaker that the issues that we're dealing with here, and many of the issues apply equally to city councils and special districts and other governance boards. And I'm hoping that the work that we do here helps give ideas to those organizations about better ways of dealing with sexual harassment with elected and appointed officials in their organizations. With that, I thank the members for being here on the panel. I think it was another very illuminating panel and something that I know is going to be very valuable as we move towards shaping a new policy for the legislature and solving the problems that we know that we have with sexual harassment. Thanks so much, everybody.